Dealing with a toxic workplace is grueling, but when you endure months of workplace bullying only to suddenly find yourself fired, the situation turns into an entirely different kind of crisis. Most assume the next step is filing an order to stop bullying with the Fair Work Commission, but this specific legal order is strictly preventative. Its purpose is to stop the behavior so you can safely stay on the job. Because you are no longer employed at that company, the law considers you permanently removed from the risk of future bullying. That renders the stop bullying order completely legally ineffective for your situation. The path to stop the bullying is closed. However, by firing you, your former employer has actually opened themselves up to entirely different, far more punitive legal actions. Companies often face a choice when dealing with a toxic culture: do the hard work of investigating the aggressor, or simply remove the target. Frequently, they choose the latter, assuming it is the path of least resistance. They will almost never put bullying on your termination papers. Instead, they'll claim poor performance, vague accusations of misconduct, or assertions of incapacity, even if your track record has been flawless up to that point. You do not need a written confession from your employer to prove the dismissal was illegal. The Fair Work Commission only requires you to identify a reasonable connection between the bullying and your termination. For instance, you establish that connection if you are fired shortly after submitting a formal complaint to HR about your harasser. The connection also exists if a colleague reports the bullying on your behalf and you are suddenly dismissed as a result. The official reason they gave you at the exit interview holds very little weight if the surrounding evidence points to a cover-up. That evidence puts the leverage back in your hands. The first legal avenue available to you is the application for unfair dismissal, known as Form F2. This application tests whether your termination was harsh, unjust, or unreasonable. This chart outlines the first eligibility hurdle, your tenure. With over 15 employees, you need 6 months. Under 15, the minimum jumps to 12 months. This covers full and part-time workers, plus casuals with a regular, predictable pattern. Finally, your base salary must fall below a strict high income threshold of $158,500. Unfair dismissal is the most common claim and usually the easiest test to meet. But its strict mathematical requirements mean that missing the tenure mark by a single week or the salary cap by $1 disqualifies you instantly. If you fall outside those metrics, maybe you earn too much or you were fired in your 4th month, you have a second option, the General Protections Application, or Form F8. This pathway hinges on a concept called adverse action. Under the law, your employer cannot punish you for exercising a basic workplace right. Reporting a workplace bully is exercising a workplace right. Firing you for it is an adverse action. This pathway also covers bullying rooted in discrimination. Targeted because of your age, gender, ethnicity, a disability, or a pregnancy, the termination itself becomes an active human rights violation. Cases involving protected attributes give you dual jurisdictional options. You can seek compensation for financial loss and psychological harm through the Fair Work Commission, or file a discrimination complaint directly with the relevant Human Rights Commission. Because a general protections claim focuses entirely on penalizing employers who violate basic human and workplace rights, it completely bypasses the tenure requirements and salary caps of an unfair dismissal claim. Navigating these two doors presents a massive strategic risk. Filing the wrong application type or bringing your case to the wrong commission can cause a completely legitimate claim for compensation to be thrown out on a technicality. You do not have to counter an employer's cover-up alone. Workplace specialists like A Whole New Approach spend every day exposing these exact tactics and offer obligation-free consultations to evaluate which pathway suits your exact situation. Getting fired after enduring a hostile work environment might feel like the bully secured a permanent victory. By analyzing the facts and selecting the correct legal application, you force the company to face severe financial accountability for their actions.